delighted you're here.
Yeah, I was going to tell you, as I started preparing for the talk, I actually decided to focus more on the domestic than the international. Of course, I'm ready to talk about the international stuff, but tonight I'm going to be, I just think that this is the moment for the Youngstown opinion in the country, and it has never been more relevant. And I've read it so many times. I teach it. It's such a fantastic opinion. I mean, it's been described as maybe one of the best opinions, or the best opinion ever, some have said, and it's so relevant. So I'm going to try to explore those themes tonight, but of course I'm prepared to talk about the international stuff too.
Most important, the biggest question, the guy comes from University of Chicago, having taught University of Illinois, is, are you a Cubs or a White Sox guy?
That's a great question. I'm actually from Oakland, California, Berkeley, California. So my teams are West Coast teams. Love the Oakland Athletics, or the formerly Oakland Athletics. Since I moved to Chicago, I try to be equal opportunity, but if I had to pick, I'd be White Sox, because it's the South Side.
Terrific. Now, as I understand it, there's just no way you could be both.
Yeah, the locals don't really appreciate that, but what, I'm just passing through. I've only been there 20 years, so. And it's very different, by the way, from where I'm from. I'm an A's fan and then a Giants fan, and they're in the same market, and it's not the same rivalry that so.
Were you destined to be a lawyer?
That's a good question. I think I first thought about it when I was in high school, and we had a mock trial team, which are these wonderful things that people, that is spread around the country. And I thought, that's really interesting, that way of thinking. But I actually was more interested in politics. I studied East Asian politics as an undergraduate. And I ended up going to law school after working for a foundation that was promoting democracy in East Asia. And the story is that this is the end of the Cold War. We were approached by the government of Mongolia to help them write their constitution. And I was very involved in that. And it got me asking questions like, where do constitutions come from? How do they work? And that experience led me to ask some academic questions, which brought me back to both law school and then a PhD as well.
So you come back to get your PhD, and did you ever feel like you wanted to do any private practice?
I've done a tiny bit, but it was never my goal. Even from the beginning, I knew I wanted to be an academic because I was driven by these questions, research questions, and they still remain mysterious to me today after, 30 years of working on them. But I think we've made a little progress on trying to understand how constitutional democracy is sustained, importantly, how it can be lost, and what we need to do to protect it. So I never tire of those questions. Unfortunately, they're very relevant in many countries today, including the United States. So I never really thought much about it. I did spend a little time practicing foreign investment law in Thailand, where I'd also spent some time. And I'd lived in Thailand before that. So, I went and practiced briefly, but I was never tempted for a career in that.
So you taught, spoken quite a bit about the rule of law and the International Criminal Court. We'll get into that a little bit later, but we're at the Robert Jackson Center, and of course he was the chief American prosecutor at the Nuremberg trial. Was that any part of your early learning when you were at law school? Did Nuremberg, Jackson, legacy, any of that come up?
It's interesting. In law school, I think Jackson mostly comes up in classes in administrative law or constitutional law. Administrative law because, of course, the Steele seizure case, which we'll be talking more about, I'm sure, but that case obviously is fundamental to understanding the scope of executive power. The Nuremberg stuff, it's more of a specialty. So most law students don't take international law. When you do take international law, of course, you learn about it. But Jackson's role I mostly learned about privately, reading history books about it. And I've always been very interested in atrocities and reparations, therefore. So that's how I came to it. And it's amazing to have a person have major contributions in our understanding of American government, very fundamental contributions to American government, and international law. That's a pretty rare combination. I can't think of anyone else like him.
I enjoyed the recent YouTube entry of you at the Oxford Union, debating a guy who's been here a lot, probably 20 times, Stephen Rapp. And give a little context there. How did you get invited, and what was the goal there? Because I found it all fascinating.
Yeah, well, it's very interesting. Of course, I've known about the International Criminal Court. I used to work in The Hague for a different court, and so I was sort of present at the founding when it was set up, and I knew many lawyers who worked there. And I followed it off and on as a scholar. They asked me if I would debate international courts, and I said, well, you know, what side do you? They said, which side are you on? I said, well, what side do you need? Just tell me. I'm a lawyer. I can argue either position, you know. So I said, you know, we really don't have anyone doing the sort of against side to raise some of the problems with the international courts. I said, sure, no problem. And I focused, of course, on the International Criminal Court. My actual view is that many international courts do a lot of really good work, but I don't think the International Criminal Court has really played out as an institution, as I explained. Very costly. Their batting average is extremely low. If you were a prosecutor here in the city of Jamestown and you went to your boss and said, you know, I have a conviction rate of 40%, I don't think that you'd be in your job very long. Many of the people have died while waiting trial. They've now taken, sort of in a very political manner, to sort of raise their profile, indicting heads of state. And I think they have 1 out of 7 who's ever been taken into custody. And I'm not sure that's a very good batting average either. So I don't think it's been a well-managed institution, even though I would support the promise of it if it could have operated better.
Of course, it's had a lot of publicity since your debate.
Yeah.
With the chief, with the prosecutor, I guess you refer to, and that removal. Has that been a distraction? Even the predecessors, we've had Luis Moreno Ocampo here, we've had Fatou Bensouda here. I mean, so we've had the players here, which has all been fascinating and interesting, but they seemingly are targets.
Yeah. Well, it's really quite unfair. The Trump administration has made a target of the whole court for no reason, and it's part of a general policy they have that I don't think is very well appreciated by Americans, of denying visas to just anyone they don't like or someone who's a friend of theirs overseas doesn't like. For another project I'm doing on term limits, I've been interviewing ex-heads of state. I interviewed, for example, Oscar Arias, the Nobel Prize winner from Costa Rica. His visa has been denied, even though he was very close with the second Bush administration. They pulled his visa back. Of course, they did the same they've done it to Supreme Court justices who have held Jair Bolsonaro to be accountable for his attempt to overthrow that government. And similarly, they've removed Fatou Bensouda's right to come to the country. It's very severe when you're subject to the kind of sanctions that they're under. It means you can't use Google. You can't use credit cards that are banked through the United States. So it's very, very hard. And of course, it's totally unjustified. It's very performative. I'm a critic of the institution, but certainly don't think that they should be. I think it needs to be repaired and fixed, not dismantled, and certainly not performatively undermined. So it's a very severe thing that's going on. It's not normal, this kind of abuse of the visa that are held by our foreign allies in many cases.
What was your role when you were, prior to your teaching, you were at the Iran
U.S. Claims Tribunal.
Thank you.
Yeah.
What was it, first of all, and what was your role there?
Yeah, it's a very interesting institution. It was set up in the aftermath of the Iran hostage crisis, which, of course, you have to be a certain age to even remember that. But the Iran hostage crisis, we will recall, was settled when we got our hostages back and we released money that the Iranians had. We had frozen much of their money. And so I know we don't negotiate with terrorists and all that, but we did give them money and got the hostages out, give them their money. Now then what happened is that there were many private American claimants who had their property expropriated in Iran. And they said, wait a minute, you can't possibly trade away my right to get this claim satisfied. These claims were already existing in U.S. courts. There's a very important Supreme Court case, Dames and Moore versus Regan, which basically says, yeah, they do have to have some satisfaction. The executive branch can't trade away your private claim against the Iranian government without some kind of solution. So what they came up with, Warren Christopher and such, was this solution. The solution was a special tribunal in the Netherlands that would hear claims brought by Americans against Iran and Iranians against Americans, as well as claims between the two governments. That was 1981. It is now, 45 years old, still going. It's a very slow-moving tribunal. The claims that are remaining are the government-to-government claims. And as you know, the governments are not any friendlier. Their relations probably have never been worse than they are right now. So that's the place where they fight about money. My role was as a clerk to an American judge. So it was set up as an arbitration body with 3 American judges, 3 Iranian judges, and 3 sort of third country judges. And it was very interesting. I learned a lot about arbitration, a lot about investment law. And of course, I actually made really good friends with my Iranian counterparts too. I'm still friends with them today. So that was nice to have sort of close personal relationships despite the government hostilities which continue.
And then were you there for like a 1 or 2 year term as a clerk?
Yeah, it's a clerkship. So I was there 2 years and I knew I wanted to get back. I had children. I wanted to move back to the States and teach. But some of the clerks would be there for several years. It's a very, very nice place to be and a very interesting practice. But no, I did come back, and again, it was really a formative experience in many ways. And again, still have a lot of good friends from that period.
So you come back, and did you have a sense where you wanted to land? I mean, we know it was kind of Illinois area for. Was that your first choice?
No, I'm from Berkeley, California. So my dream was to be a professor at Berkeley Law School, and then it was called Bolt Hall Law School. And for whatever reason, they weren't interested in me, and I don't know, maybe it's too much information, but they got interested in me after I got a job at the University of Chicago. And then I thought, well, at that point, my life was more centered in the Midwest, but I still go back to Berkeley a lot. I have no regrets whatsoever. The University of Chicago Law School is a very special institution. It's a very intense institution, and I've been around a lot of institutions. I worked in government, I worked for this court, I worked for private firms briefly, foundations. I've never seen an institution as sort of functional as our little department at the University of Chicago. It's just a very fun place to be. We debate issues all the time, we're always arguing, and we're always just trying to get it right. So it's a very special place.
Well, I commend for those who watch this that when you Wikipedia, with the source of all knowledge, of course, your page, you have a tremendous amount of literature you've created. And I pawned through a few of that in anticipation of this. And but did you find when you went there, was that the niche? You've got a niche,
yeah,
a unique, wonderful niche. But did it start off that way?
Well, I think I was, again, my academic trajectory goes back to the questions I started to ask that got me into graduate school about constitutional democracy. And my first book was on judicial review. Where does judicial power come from? It's very relevant to the Robert Jackson Center, of course. How is it sustained? And I had a theory of that, but it was developed in East Asia, where I'd been doing some work. And that book got a lot of attention. And then I decided, to sort of go even bigger. And I have a huge data set of all the constitutions ever written. I explore that using statistical methods, using all kinds of methods. So I do a lot of work in constitutional democracy around the world. I write a lot with my colleague named Aziz Haq. We wrote a book called How to Save a Constitutional Democracy right after the first Trump election. And he's actually from Britain, but he's an American constitutional lawyer. I'm American, but I really work mainly outside the United States. But of course, now the questions are common across all kinds of different contexts. And I'll say also that I also work on public international law. I've always done that. Again, my primary concern there is the relationship between international law and constitutional democracy. What can it do to help support and facilitate democratic endurance? And the answer is something. It's it's pretty relevant in a lot of countries.
couple of names which we've had here who had prior careers at the University of Chicago. Bernie Meltzer,
Oh, wow.
and Abner Mikva.
Yeah.
And do your paths ever cross with them? I mean,
Bernie, I think, had passed away just before I moved there. But Ab, I knew pretty well because I happen to be friends. One of his, I guess his son-in-law was my colleague at the University of Illinois, Urbana-Champaign. So I spent a lot of time with Ab over the years, met him many times. And what a person. He's one of very few people to have served in all three branches of the U.S. government, like Chief Justice Taft is another one. I can't think of too many others. And just absolutely dedicated public servant. So our law schools actually started a MICFA award that we give out. I think that started last year. It was given to David Rubenstein, who's the philanthropist, who's the chairman of the board of the University of Chicago. So, he's really something. It's I should add also, it's wonderful to be at an institution with such a history, because Obama taught there, obviously. Elena Kagan, well before my time. Cass Sunstein was a colleague for a short while. One of the people I got to meet when I got there was a man named Ronald Coase, who is a Nobel Prize winning economist who taught in our law school for many years. And when I got there, he was in his late 90s. And he lived in a senior center. I would go talk to him, and I would talk to him about China, where I'd spent some time. And he was very interested in the topic. He was actually working on a book on China. He published his last book at the age of 101.
oh my God.
And it was on China, a country he'd never been to. So it's special to be part of places where you have this sense of history and a sense of mission that would drive someone to keep writing till they were 101 years old. I love that.
Was Milton Friedman, was he in Chicago?
Yes, he was in the econ department. I never, well before my time.
And the most important person who's an alum is the first Heisman Award winner, was from the University of Chicago, Jay Berwanger.
Yes. I had never heard of him until my judge, actually, at the Iran-U.S. tribunal said, "Oh, you're going to University of Chicago. You got to research Jay Berwanger." So, but famously, the school gave up its football team. There was a president in the 1930s and 40s, Robert Maynard Hutchins, and he said, he had his expression. He said, "Football, fraternities, and fun have no business at the university." And so he closed the football team down, and I think they put a library up at where the stadium had been.
Yeah. But I corresponded with Mr. Berwanger. That's a long story, but
Really?
yeah, it wasn't that. He lived a very long life, but since he was the first, always the first, and he was a businessman, and he was just one of those guys. I digress. So you have, I'm sure this year and last prior, challenged by the whole concept of the sustainability of democracy, the concept of rule of law, and the relationship of the two.
Yeah.
Because in the business of which both of us are in, the Constitution is your touchstone. And within that, of course, is the rule of law and the compliance with the rule of law, when in fact, that's seemingly a conversation. How are you dealing with that, and how are your students dealing with it?
Well, it's a very challenging time, of course. First of all, I think about the two as being very closely related. You can't really have democracy without the rule of law. And a very easy way to see that is, how can you have an election if the people counting the votes are not acting according to rules that are laid out in advance, if they're not supervised by judges? So you need the rule of law to have democracy. There is some tension, obviously. Sometimes you get populist majorities that say, we're the majority, we want to do everything, and there's limits on that. So how is that sustained? It's a very challenging time, and it's clearly our country's going through what you could call a stress test right now, without question, of its institutions. Now, the first point is that we're not alone. Other countries have experienced this kind of thing, and there have been some cases where there's been some rebound, and I think we now need to be looking at those cases to understand how it is that backsliding, we call it democratic backsliding, is arrested, and then how recovery can occur. We need to learn from the experience of other countries. Of course, we have our distinct institutions, and to be honest, in the midterm, I'm not pessimistic. A lot of people are really pessimistic. I'm an inherent optimist, And we're seeing a lot of short-term damage to, or maybe long-term damage to many institutions. But, you know, one thing about this country is people are never going to give up their right to vote. And they really want to be able to speak freely. And so I think we have a culture which is going to help save us. And that's not true of every country. We've got a deeply rooted, you know, sort of libertarian streak, one might say. And there are limits, I think, to what authoritarians could do in this country. But at the same time, I really like to see things turn around and move towards a position where we all recognize that these institutions are critical. You can't just have what you want immediately all the time without institutions. It just doesn't work.
Is there a reset in all of this where you study constitutions?
Yeah.
And we're enjoying our 250th from the Declaration of Independence, Constitution a few years later. But we've had very few amendments to the Constitution, remarkably few.
Mm-hmm.
And does that conversation ever come up, or does it come up a lot?
Sure. Right. Well, there's a lot of people, including some colleagues in the academy, who think that our Constitution is undemocratic, that it ought to be replaced. And there's actually a way to do so through Article 5 that's different than the usual amendment process. If 2/3 of states call for a new constitutional convention, we could have such a convention, and they would make proposals, and they would again have to be ratified by 3/4 of the states. So there's actually a movement afoot to call such a convention, and a bunch of active calls out there. Now, I have a lot of problems with the U.S. Constitution. You know, if we were writing it again now, it would be a very different document. I analogize it to technology. You know, we're not using many technologies from the 18th century. I didn't come here in a horse and buggy and such. But our technology of governance is sort of fixed and very hard to update, as you said. But were we to rewrite it again, I don't think it would be a good thing. I think it would be a very divisive process, given the state of the country right now. And I think that it would be much better if we were just able to work it out basically through extra textual means, and that really is what we've done. The administrative state really was a kind of extra textual amendment to the Constitution. The right to privacy. We have all these things which aren't in the text that we've managed to adopt as constitutional to help us live together. And that's the process. That's I think the only process that could work at this stage in American politics.
If you had, because you at the University of Chicago, this is George Fector, a good friend of the center's, and he heard I was going to be talking to this celebrity.
No, I don't know.
So, would you at the University of Chicago and your center there looking at constitution analysis and have a database that goes back to really our first, do you go through the exercise in your law school of starting anew?
You know, I sometimes will ask the students what amendment they would do if they could amend anything. And there are people who do mock constitutional conventions. I think that's a great teaching exercise. Figure out what we would want to keep, what we'd want to start over with. And again, it's like technology. If we were to do it today, if we were to start over again today, there's all kinds of discoveries that have occurred in the field of government that we would adopt. So one is a constitutionalized accountability institutions. Things like a counter-corruption commission or an ombudsman or something like that, that provide for a neutral body that is protected by the Constitution to watch what the politicians are doing. Almost every constitution that's been adopted in the last 30 years has such a thing, and so I think we would definitely do that. We might have different set of rights. I think we would probably ensure that electoral administration was done in a nonpartisan way. One of the great mistakes of the Constitution is that Madison and company gave electoral administration to the state legislatures, which again, they didn't think there would be political parties, so they thought they were giving it to sort of grand old men who would have the public interest in mind, but that's not how it's played out. We do know that those states that have adopted nonpartisan electoral commissions have fairer elections. So I think that's something we would definitely do. So all kinds of things like that we can learn from the technological developments. And but it might be possible to adopt many of them at the subconstitutional level.
You have, occasionally I'm sure, reflected back on the amendments that have occurred. Are some of those that have occurred, which at the time we thought was clear, were provided a degree of clarity and contemporaneousness, have not worked?
Well, the famous one.
Aside from the alcohol.
Yeah, exactly. I actually teach a class on prohibition specifically. Okay. So it's called Wine and the Law. It's one of my sort of elective classes I teach. And the legacy of that, of course, is still with us. But so that's one that we adopted and then undid. That's one way to go. The other amendments, it's interesting. I mean, many of them are fairly vague. The 14th Amendment, obviously it leaves a lot of room for interpretation. It's become a huge fountainhead of constitutional law for us ever since. I guess I would say the one I'm working on right now is the term limit rule, 22nd Amendment. 22nd Amendment could have been written a bit more clearly, honestly, because it says no man shall be elected, no person could be elected twice as President of the United States. It doesn't say no one can serve more than twice. And now there's all these discussions going out there, very speculative, but about whether President Trump could try to run for another term by being elected vice president, for example, and then succeeding, or that probably wouldn't work because of the 12th Amendment, but maybe he would be able to be elected Speaker of the House. Rather oddly, you can be elected Speaker of the House without being a member of Congress. And then the Speaker of the House is third in line to the presidency. So there's all these kind of speculations. They could have drafted that a bit more clearly, but there was such a consensus they didn't think they needed to. Generally speaking, I think the problem we have is too few amendments, not too many.
Is it too hard to become?
Yeah. Yeah, the last one was adopted in 1992, but it had been proposed back in 1789, and it was about the pay not being subject to increases without intervening election for Congress and such. And so that was actually adopted at the instigation of a student at the University of Texas in the 80s. He was doing some research for a class paper, and he discovered this proposal had been made in 1789 and had never been ratified by all the states. He said, wait, it's still alive. It didn't have an end date on the proposal. And he kind of went and pounded the pavement and got this thing adopted. It's quite a story. But generally speaking, it's far too hard.
That particular story, I read that too, because I think it got some publicity maybe a couple of years ago. He's still alive.
Yeah. Yeah, he's not very old. I mean, he was a student in the 80s. So, yeah. And my colleague at the Comparative Constitutions Project, Zachary Elkins, interviewed him and brought him to class and sort of helped to dust off the story, because even until,
that's what I read.
I think so. But it's an amazing thing about what a citizen can do. It's a great story to inspire people.
I'm going to segue a little bit. I had a chance to meet, and unfortunately wasn't interviewing at the time, but Shirley Chisholm.
Wow.
Because she was living in Buffalo towards the end of her life. And I communicated with her and met with her, but I didn't have this. And to this day, too bad is right. But you talk about her.
Yeah.
And in your conversation about she and examples of, well, you talk about her.
Well, so she's one of my heroes. I learned about her in high school in Berkeley, California. We had classes in African American studies and African American history. I took those classes and I learned about Shirley Chisholm. And then I started to read some of the things she had said and done. I was so inspired by her. One of the moments I talk about, which is really important for us to think about today, was after George Wallace had been shot by an assassin. He was in the hospital. And George Wallace was a segregationist, racist governor of Alabama. And Shirley Chisholm visited him in the hospital. And she walked in and said, you and I disagree about everything, but you've been shot and I could have been shot, and we can't have that in this country. And I just thought it was such a moving moment he didn't ask for this, but it changed his life. It changed the way he thought. He later became a Christian, and he renounced some of his earlier positions. Wow, if Shirley Chisholm and George Wallace can talk, we surely can do it better as a country today. And so one of the things we need to do is to be able to talk to people with whom we disagree with politically. We are bound to live together in this huge land and with an amazing history, and so we've got to work at it. It's not going to happen on its own. So one of the things I do is I run something called the Forum for Free Inquiry and Expression at the University of Chicago, and that's one of our missions, is to get people, students, but then outsiders as well, to be able to have the skill to talk with those that they disagree with and realize it's not existential, it's just trying to understand where the other person's coming from, and you don't have to agree. But at least after the conversation, you'll have a better sense of who they are as a human and maybe be a little more empathetic and not be inclined to demonize people, as happens so much on social media.
I think one of the speeches I listened to, you also talked about South Africa as an example and Nelson Mandela. And I want to talk a little bit about that.
Yes, it's also an amazing thing, right? So in South Africa, you know, they had obviously an evil regime, an apartheid regime, and they struggled for many decades. And when it finally came to an end, first of all, the constitutional process was critical because they bargained. They came together and they negotiated the transition, knowing that they would have to live together. And that involved recognizing that it would be majority rule, but also that the minority, the white citizens, had certain interests that had to be protected in order for the country to go forward. And it's an amazing bargain. It was a source of many institutional innovations, and the process is one that we study in my field, and even sort of promote, if you will, as a model for other countries that are deeply riven. Of course, it took someone like Mandela to be able to pull that off. I think so, because he had this stature. Like George Washington at the founding of our country. Everyone knew in the negotiation of our Constitution that George Washington would be the first president. And that took a little pressure off the negotiations in some sense. They realized, okay, we're going to have a leader for at least the first period. And South Africa was the same thing. And his stance towards reconciliation set the tone. South Africa's got a lot of problems, but they're muddling through as best they can.
I always read about South Africa that, and actually I did interview Richard Goldstone, Judge Goldstone, who was on the court, and then it seems to me that there was this reconciliation, I don't want to say tribunal, I'm not sure what it was, but what was that?
Well, they had something called a Truth and Reconciliation Commission. So this is always a problem when you have regime transitions. It's one we are going to face ourselves, I think, because of the criminal actions by some of the people in the government today. And I don't want to get into all of it, but there are some crimes that have been committed. Then the question is, do you prosecute them or not? And it's a much bigger question when you have mass atrocities like apartheid or something like that. And of course, that's what Justice Jackson's work at Nuremberg was setting off as well. So who do you prosecute? How far down do you go? How severe does the crime have to be? These are really important questions. What they decided to do in the spirit of reconciliation is not emphasize the criminal prosecution and punishment, but emphasize reconciliation. So the idea is that if you were involved in the apartheid regime, you were a security guard and maybe tortured people or killed people, you could be forgiven and have no punishment if you would come tell the truth. And that would allow the victims to confront you, and there would be a process, but it didn't involve punishment, as long as you told the truth. If you didn't tell the truth, you would be criminally prosecuted. It was a model for how to do these things, and I think when we see other mass atrocities, Rwanda, it's not quite happened in places like Cambodia, but it could be a model where you get people to at least come forward and establish the historical record. That's pretty important thing to do. So it's one of the tools that's out there for transitional justice.
You also mentioned, I don't want to go through all this list, but Northern Ireland and how it really was more or less a citizens group that sort of helped bridge a gap.
Right. This goes to the question of how do we think about democracy in the 21st century? Our sort of technology democracies, you go every 2 years and you drop a piece of paper in a box, and that's basically unchanged since 1789. Well, now where everyone lives in the digital world, we're online all the time, we could have more more frequent participation. We could have more frequent engagement with each other. And there's a lot of discussion now about ways to reinvent democracy for the 21st century. One of the Irish Citizens Assembly was an example of what we call, well, it's a citizens' assembly where they curate a public. They get a group of people together who look somewhat like the general public. So it's not just random citizens. And they make proposals about governance and what should change, and they do it after deliberating. And so it's a very different model than just giving your view as a vote, as a single yes or no on a question. It's, well, let's discuss, what should this look like? That citizen assembly made a proposal, and that proposal was then adopted by referendum, and that is how Ireland legalized abortion, which is a massive change for a country that had forbidden it. Irish women would have to go to England if they could. Many didn't. There were lots of problems. And so you can tackle big questions with ordinary citizens, is what that tells us. And, you know, Northern Ireland's not a huge country. Ireland's not a huge country. But that happened in Ireland itself. And then Northern Ireland is a case where there's been this discussion of, again, a truth and reconciliation kind of process for the Good Friday Accords, which, again, it's an amazing story if you think about how long that conflict had gone on. I consider those things very inspirational. You know, now we have Israel and Palestine. It seems like an intractable, unsolvable conflict. If the Northern Irish could solve it, you know, all conflicts can come to an end. They just require the right alignment of people and the right folks to facilitate the process and the right interests of outsiders at the right time.
Have you brought any of the Irish, you know, the Good Friday Accord? I mean, there's a couple still alive.
Yeah.
Have you brought them to Chicago?
I've talked to them, yes, although I don't, not in recent years, but yes, I did have someone come and visit, and yes, but you know, but it's not been a major focus of my work because I'm, you know, coming sort of from a different part of the world. I spend most of my time studying East Asia. But we do try to, now we're trying to do more things where we sort of have more working level models and experience for students where they can participate in something like this. Sometimes we do it as a mock, you know, class or something like that, where they get to pretend that they are the ones who are doing the negotiation. So that's a nice pedagogical technique a lot of people are using now.
I don't know anything about the question I'm going to ask, but what's the status of Myanmar?
It's a mess. So yes, I did a lot of work there. I first went maybe in 2006, I think. So that was in the heavy military period. They came out with a constitution in 2008 that most of us who had observed the country thought, oh, that nothing's going to happen with that. It's like a fake constitution. We were very wrong, because that constitution allowed a kind of transition to a mixed or guided democracy where the military was cohabiting with an elected government. And of course, Aung San Suu Kyi was never the president. She couldn't be president because she had been married to a foreigner. But she was the de facto power behind the parliament and behind the democratic apparatus. And then the whole thing broke down for really, really tragic reasons. The commander-in-chief of the military at the time was going to be rotated out. And he as militaries do, he didn't want that. He wanted to be able to stay around. She wouldn't let him do that. She just said, you know, we got to follow the rules. And then they had the coup. And so now Myanmar has been, it's now at least the 5th year since the coup. They've been always had a civil war since the founding of the country in 1947. But now it's really, really severe. I understand that the military controls less territory than it ever has. But at the same time, it's not a situation where the rebels are going to be able to dislodge them completely. So it's a very tragic thing with, you know, hundreds of thousands of people killed just in this period. And the world hasn't paid as much attention to as it should, but it's another one where hopefully eventually there will be some sort of reconciliation.
Just locally, we have an attorney graduate, not so young anymore, but who went there and continues to be there, you know, working on the kind of the international law side of it. And occasionally he'll come back and call me and talk about it, and I really don't keep track of it long enough.
Well, it's pretty interesting how I've actually taught there the last few years. I teach remotely, so I will teach for the for a group that is educating Myanmar students all over the country digitally, or through Zoom type of things. And so I can give a lecture, and there'll be someone sitting in northern Wa State, and someone down in Kachin territory, and someone in the center of the country, all online, and you hear the chickens and cows in the background, and we're talking about constitutions and thinking about how to design institutions for a future Myanmar. So that is one good thing that's come out of this, is that the opposition is unified, and they're spending a lot of time trying to think about what institutions would look like, which hopefully would mean that the ethnic groups, which is a huge portion of the population which has always been shut out, and the democratic folks around Aung San Suu Kyi could at least have a consensus among themselves. No, it's a story of resilience, but also deep, deep tragedy.
So much, period. But the international criminal law is something that we annually pause and have the former chief prosecutors from Sierra Leone, Cambodia, Yugoslavia, Rwanda, they all come here. And there was a time early on when it was very active courts. But with that, the wind down of those were really, it's just the International Criminal Court and as a bunch of residuals of that court. Is there any future, do you think, as you look at this, for that concept, or was that just something that was created in a certain time? This is, 90s, 2000s.
Yeah.
You get a sense of that?
There was a moment in the first decade of the 2000s when we really had a lot of things going on which sort of pushed towards more accountability. Not only was there the development of these courts in many different contexts, many specialized courts, but also the responsibility to protect doctrine, which looked like it would be a thing. But by the second decade, that had ceased to be a very viable thing. There weren't very many promoters of it. And I think it's also true of the International Criminal Courts. It's been pushed mainly by the Scandinavians and the Europeans. They're the ones who fund it. And my concern is that as those governments also turn a little bit rightward, that they're going to be less concerned with that, just as they've become a bit less concerned with democracy promotion and democracy assistance. So the whole world of international institutional infrastructure to promote, human rights, democracy, liberal accountability, it's fragile. That doesn't mean that the project's over. I think what we're going to see more of in the criminal space is prosecution by specific countries, either on the basis of universal jurisdiction or something else. I mean, in a way, the Trump administration is opening the door to this with their kidnapping of Maduro and their indictment of Raul Castro. Those have problems, head of state immunity and such, but what they suggest is that there's still going to be criminal accountability, but it may just be those other sort of older forms. And that's you'd have to do a sort of deep analysis to say, is that really worse? It depends what, power is always going to be involved. Power is always going to be involved. It was involved in the International Criminal Court. It was involved in Nuremberg. So the idea that you're sort of in a power-free zone of justice, I think, is a non-starter to begin with. Can we get institutions and prosecutions that get the worst of the worst and incentivize them to behave a little better? I think that would be a very good thing if we could do that.
I get a sense from the conversation nowadays among those former prosecutors, because they still come, they kind of like they're each other's company, is gathering their best practices and actually trying to educate the domestic courts. Elevate the judges, elevate the infrastructure, so that that's where the rule of law may ultimately preside, rather than an international consortium. Does that make sense?
Well, that's clearly true. But in general, when it comes to democracy and the rule of law, the international community can help. It can play a major role, especially for smaller countries, in backstopping things and providing resources and such. But it's never a substitute for the domestic institutions. Domestic institutions are very fragile, as we're learning, but we also know something about how to build them up when the political will is there. So I think that is the right approach. And the other part of the whole international criminal justice enterprise is the documentation part, the facts that get created. We don't think of courts as sort of knowledge institutions or truth-generating institutions, but they are. They provide a authoritative record on the basis of rigorous presentation of evidence, and that function is a historical one, which is also very important. It might be hard to do as well at the domestic level. That's one nice thing that the international criminal enterprise has done.
Well, I harken back to Nuremberg and Jackson. The record upon which we build today is the record upon which we may be judged tomorrow. I mean, that concept, which you had to have a record.
Mm-hmm.
And I know that even some of these tribunals, which have ended in either quickly or without conclusion to the satisfaction of the prosecutors, they often harken back on, we have a record.
Mm-hmm.
Now it's through the normal rules of evidence, etc., that it was created. Otherwise, you wouldn't have it. It's just an oral history, and it goes with the wind.
Yes, yes.
And I think, to your point, I think.
Yeah, absolutely. And we see that there's something about those periods, Nuremberg and the Tokyo trials. There's a great new book by Gary Bass on the Tokyo trials. They really repay continued attention for what they were doing and what they were trying to do. And a lot of criticism, particularly of the Tokyo trials, and it's well warranted. But what that does for a national narrative is pretty important, I think. And so in other words, we tend to think, oh, it's a court. It's operating at the level of the individual criminal who is being punished. No, these are much more cultural interventions, and they function at the level of history, at the level of national history. And so that's why it's important to get it right.
On getting it right, this you're going to say, what? Where's your segue, Greg, in all of this? Your teacher extraordinaire, high level. This is Professor Tom Ginsburg. What does AI mean to you these days?
That's a great question. And well, first of all, we have to confront it. We can't just pretend it's not happening. And I've used it a little for research. I find it very helpful, but you got to check every source. I don't trust it yet. The writing I find very bland, so I never write with it. I never, take a sentence or something from it, but I can use it to find quickly, who said what about what and things. So that's very helpful. I think as a teacher, it's a big challenge. And we at the University of Chicago Law School are actually trying to get ahead of this, because we recognize that if you're going to be a great lawyer, you're going to have to understand how to use this stuff. But it's also important to think like a lawyer and to learn about these concepts and to really internalize them so you can tell what the AI is spitting out. And so what we're doing, it's a big experiment, but we're going back to the system as existed when I was in law school, because I'm that old, where you took notes by hand. There's no devices in the first year of law school for this coming year at the University of Chicago. Very big change. But then in the second and third year, we hope to teach you, how to use AI responsibly, how to use it most efficiently in terms of your research and things like that. We think that, at least for our lawyers, our students, that they will have the most impact the people who will have the most impact will be those who know how to use this very well. And so that's the kind of lawyers we're trying to train. As an individual professor, I don't know, I haven't really confronted it, but you could imagine a thing where you ask the student the question, what is consideration in this case? And they're like really quickly recording you and then having the device spit out an answer, so there's no learning at all, they're just processing. So that's what we have to avoid.
Because I go back to the Paper Chase, the movie. I'm sure you saw it.
Yeah, I think, yes. That fellow who wrote it was my legal writing instructor.
Oh, is that right?
Yeah, he taught at Berkeley years later.
Did he talk about it?
Not much. We try to be tough. I mean, we're a very Socratic institution, but I think there is a bit of a generational change. Things have softened a little bit from the old days. It's just a cultural change. But we want them to be, how to put it, scared enough to be prepared, I guess you'd say, and that's the goal.
Are you in your profession a publisher parish world? Is that a reality?
Well, not.
I know you publish a ton. But
Yeah, I mean, yes, that's right. If you, one of the wonderful things about my particular department is everyone writes. Every single person is publishing. We don't have people who, checked it at the door and stuff. And so, yeah, I mean, if you don't write, you're not going to, here's the theory. There's kind of an idea out there that sometimes you hear, oh, I put more emphasis into my teaching and not my research. That's not our idea. Our idea is that to be a great teacher, you have to be at the cutting edge of your field. You have to be writing. So the two things are quite complementary. They're not substitutes. And we do want our young people to write not only a work, but it has to be really good work. It's got to be work that is at the cutting edge of their field. So we have a pretty challenging standard, but yeah, I mean, I think it's important. Now, what exactly is the value of research is another question I think we have to ask ourselves. What is the research that AI cannot do? What are the things that AI cannot do? And then maybe that's where we need to be channeling our energy these days. I don't think it is a substitute for human thinking, but it's not a field I follow very well. I think it is going to be a substitute for judges and arbitrators for sort of low-level things, and certainly for lawyers doing basic drafting things, drafting a will or a trust or a contract. It's already pretty good at that, I think. It's certainly a serviceable one. So again, how do we get our folks get our students to be able to use that well, and how do we get our scholars to be producing knowledge that will contribute to human flourishing in this environment and will do the job responsibly? I think that's something we're just starting to talk about.
So you decide a topic. I mean,
Yeah.
you can say, I'm really interested in this topic. I want to study it. I want to research it. I'm going to actually hopefully get some people who will assist me, research assistants, so I can write this. Is there anybody above you who says, that's not really a good topic?
No.
I mean, you've got that independence?
Yes, absolutely. So that's the idea of academic freedom, that you have freedom to research what you want to, and freedom to teach the subject in the way you want to. You can't, I often say I can't go teach the laws of physics in my class, but I can teach law the way I want to. Now, with the research, of course, no one tells you what to do and not to do, but there's kind of a economy of respect. And we know, because we read other work, what's the good work and what's the bad work. And that's the reward. You want to be the person doing the good work. And if you're not doing good work and before you have tenure, you won't get tenure. You won't be allowed to stay in the job. So it's more rigorous, I think, than the public understands, even though we don't, in the end, have a direct boss saying do this and do that.
Yeah. Is your peer review? So when you do your subject, and you've done so many of them. I mean, I just love talking to this because I don't understand it all.
Yeah.
But you do something and you submit it out to a journal. It could be whoever publishes it. It's now out there in the domain.
Yeah. Well, we have sort of for law professors uniquely, we have some things which are not peer reviewed. For most fields, everything is peer review. If I read a book, that would go out to some folks to review and make sure there was a high enough quality they'll make suggestions. So part of the production process is blind peer review. It improves the work. Now in law schools, we have this unique thing called law reviews, edited by students. And the students are the ones making the choices about what to publish and what not. So that's not really peer reviewed. And that process has, trends and things like that. And there's some good things and some bad things about it, but the selection process is a little bit more random. Most of my colleagues don't put a lot of stock, at least in my place. You got something in the Harvard Law Review or Yale Law Review, okay, that just means those students liked it. We try to read the work. If it's in the, Miami of Ohio Law Review, that's just as good for us if it's good work. We try to discount the placement precisely because of that. So it's tough. What it's really tough for is if you're in a law school and then you have to explain to a provost who might be a chemist or something like that, oh yes, this person has all these articles and they're in the Harvard Law Review. And then the provost said, well, who edited that? Who chose the article? Students? What? It doesn't make sense. So we have a little bit of an explanation we have to do inside the academy about that. University
of Chicago has a huge, high reputation as one of the preeminent law schools in the world. Do you look at rankings compared to other law schools I mean, Chicago's always in the top 5, 10, but is that ever a conversation?
Well, you know, the deans have to pay attention, and I was a deputy dean for a while, so I did pay attention to it. And we do it, what's the word? We know that the rankings are somewhat arbitrary. The U.S. News is changing the formula every year. It doesn't pass basic social science muster for a good measure. And I would much rather see the tiers instead of an ordinal ranking, 1, 2, 3, 4, like 2 is really better than 3, and 7 is really better than 8. That's sort of misleading, actually. I'd rather see these are the excellent, these are the very good, something like that would be better. But yes, we do pay attention because it materially matters for us in the sense that the students will pick their law school by its number. We were bumped this year to number 2. We're in a tie for number 2. So what we know is that means more of the students to whom we made offers of admission will accept. So you kind of have to pay attention, like it or not. But at the end of the day, the formula is driven very heavily by factors that really don't go into quality.
Right. When you want to do something in law, is there something you might do other than this?
Nothing. Couldn't be happier. I wouldn't trade it for anything. And I just feel very lucky to have been able to kind of come up with, for academics, one of the hardest things to do, you could have some very smart people, but they never have a good project. They never have a question that drives them forward. And I've been very lucky to have some questions, which I'm still trying to answer, but it really drives me forward. And so I feel very, very fortunate to have just been in the right place and time, to have been exposed to some of these countries around the world, and that has driven my questions. So I wouldn't trade it for the world.
You're primarily, this is Wikipedia, the source, this is it. I mean, primarily known as a scholar of international comparative law with a focus on constitutions and a regional specialty of East Asia. Now, when you read that, you'd say, that's correct?
Yeah, that's correct. But I have been doing a little less on East Asia the last few years and writing much more on, I've been very interested in what's going on. I'm really now a very global person. So I think there's a lot of interesting developments in Africa with regard to the rule of law. I think, Latin America, there's some developments, maybe not so pleasing, but I really try to pay attention to a lot of different countries now, as well as keep a hand in my East Asian thing. I lived in Japan, I've lived in Thailand, I lived in Mongolia, so I have some, what's the word? Close relationships there, and it's just a part of the world that I love.
Do you get calls from governments or maybe NGOs and say, I'm working, NGO might be working in a country that's really struggling with the Constitution, say, could you come here and we'd like to have you come and help us develop a Constitution?
Well, I do a lot of that, and I do it, sometimes it's the country, sometimes it's an international organization, the UN or something, and it occurs at every stage. Sometimes it's come talk to us about what constitutions can do for our current problem. So I happened to be in Chile in the fall of 2019 when they had this huge social explosion. And so I came down and just gave some lectures about, well, these are the things constitutions can do and not do. And they ended up starting a constitution making process that they took 2 tries and they didn't actually get a new one. But that process was a very public one. So, I would go down and talk about things from a more general perspective. In other places, you're sort of closer to the action of where decisions are getting made. But I do a lot of work with an intergovernmental organization called International IDEA, the International Foundation for Democracy and Electoral Assistance, and they're based in Sweden, and they're very interested in this stuff as well as other aspects of democracy. So yeah, I do some of that. At the end of the day, it's easier to say what not to do than what to do, right? Constitutions have to fit the local environment, and also a lot of the solutions are pretty, if you adopt a parliamentary system or a presidential system, it's very consequential for local politics, but there are many good ways to design a constitution. I describe it a little bit more like lawyering work, where you're reading a draft contract, you say, well, you better not have that clause because that's going to interact with this one, and then that bad thing could happen. So that's how I see the role. It's like a lawyer's knowledge is actually very useful in this area.
Riddle me this. You and I live in the wild world of a legal system which resolves itself, evolved from the common law of Great Britain.
Mm-hmm.
English common law.
Yes.
And over time, we've got a constitution which sort of trumps everything. We have the constitution that leads us, but we go back to the mothership, England. They don't have a constitution.
Yes, right.
How do we reconcile that?
Well, it's a very unique thing. When I first was doing my comparative constitutions project, my colleague Zach Elkins and I, we were gathering all the texts from all over the world. There's a few countries which don't have a single written constitution. That would include like New Zealand or Israel or Saudi Arabia. So we came up with analogies there. When I got to the United Kingdom, we went to the something called the Constitution Unit at University College London, which studies these things. And we said, well, what is the British Constitution? They're like, well, we know it when we see it, if you will. And I think they were able to do that because English elites for centuries came from a very small class of society. Everyone had been educated at Oxford and Cambridge and stuff, so they could get by on conventions, and some statutes were constitutional, other ones were not. Some precedents were constitutional, other ones were not. And they all kind of knew it because they would talk to each other. I think that's breaking down, and that's one reason they now have a Supreme Court. And it's obviously totally inappropriate for a country of our size and scale. We are defined in this country by the Constitution, and without it, we wouldn't be a country. It's what brings us incredibly diverse people together, and it's what's made the country thrive for 250 years. And again, I don't think it can be easily replaced, or that I don't think we should try. So hopefully we'll last another 250 years, which, as you know, would have completely surprised the founders. They would be stunned to know that this experiment, this republic, was still going, because they thought republics, sort of rose and fall. They studied history, and they didn't believe that anything would be as permanent. And certainly, I doubt they would have predicted we'd still be here 250 years later.
What do you do in your downtime?
You have to have something that you don't do, that you're not working all the time. So, I play guitar as an amateur. I'd like to do that. I play the game of Go, the Chinese game, a Japanese game. But basically I've been working pretty hard the last few years, not so much I'm working hard on my scholarly work, but I'm running a couple institutions at the University of Chicago, and that's taking up quite a bit of time. So I'm getting to the point where I can see the light at the end of the tunnel of establishing these things, and I'll be able to enjoy myself a little more. I also should say that I for many years made wine in California, where I'm from, and so that's a hobby. That's why I teach the wine law class. So yeah, I have fun. I'm not working all the time.
Well, I got to believe the wine law class is a very popular one.
Yes, I think it had the highest waiting list in the history of the law school last year. But it's a small class. I can only do it with about 20 students. There's a lot of law. We talked about prohibition. After prohibition was repealed, states, as you know, have been able to maintain all kinds of sort of arbitrary rules, and there's an interesting interaction between those rules and the Commerce Clause, the general rule which says, we're basically a free trade association inside the country. So the Supreme Court is always kind of navigating that. So there's a lot of law in this country, a lot of law in other countries. So it's a very serious law class, but it's a 2-hour class, and I give them the option of another hour, which they can stay around and we'll do a tasting of a different grape each week. So that it's a popular class.
Interstate commerce. This has nothing to do with anything but other than it came out of an Illinois court system where baseball. I'm a baseball guy.
Okay.
I play baseball.
Who's your team?
With Detroit Tigers. I'll explain that off camera. But baseball has uniquely under the Constitution an antitrust exemption.
Yeah.
And it rarely runs its way through the original federal case. Judge Kennesaw Mountain Landis, Chicago, Illinois, and all of that stuff. And yet here we are, fast forward, it still has its antitrust exemption, and every other major sport does not. Have you ever mused about that?
You know, I'm not enough of an antitrust expert to know the consequences. I don't fully get it, whether it makes a difference. I mean, it seems like most of the leagues are able to, the owners kind of get their way and they have a commissioner. I will tell you on the record, I'm not a fan of the current commissioner of baseball because he allowed my Oakland Athletics, the team I followed since I was a kid, which has been to the playoffs a large number of times in my lifetime. He allowed them to be moved, now first to Sacramento and eventually to Las Vegas, when there was another offer on the table. It's really decimating for the city of Oakland, and I can't, it's actually hurt my willingness to go watch the game, although I've been to a couple this year.
So you've extracted that. There you go, Rob Manfred. There you go.
Yeah, exactly. I hope you're watching.
You were a good sport about being willing to come here today.
Yeah.
And sit down and be interviewed. In anticipation of that, I don't know if you gave any thought to it all, but was there a question you thought I might ask that I haven't asked?
No, I had no idea what to expect, and I'm very impressed with the being here, the facility. So I can't think of anything that we haven't covered that you'd want to know about me. But I just appreciate the work of the center. I think it's a really important legacy to honor, and a really nice way to do it is to bring people here and to treasure this champion of the rule of law, Robert Jackson.